Hello, everyone, and welcome to our webinar on advocacy, elections, and nonprofits. Thanks for your patience. We're glad that you can join us today on this important subject. Basically, we have two areas, elections and lobbying. We have an election coming up on November 3, which will have historic consequences. And then also, secondly, we as nonprofits are called to be civically engaged, to get involved in elections. But when we overlap those two, elections, lobbying, and nonprofits, what can we do and what can't we do? What should we keep in mind when we're civically engaged? And we're very fortunate today to have expertise to answer some of your questions about what is allowed and what is not allowed. And at the Alliance here, Arts Alliance Illinois, we're honored to partner with Chicago Lawyers Committee for Civil Rights and Quarles and Brady to make this possible. But before we jump in, a few just kind of logistical details. Please feel free, as some of you have already been doing, to use the chat box to say hello and to connect with each other. And you'll also see a Q&A section there. There'll be a Q&A at the end of the presentations, at the end of the panel, and we welcome your questions. So you can post your question, but if you see a question in the Q&A box that you like, there's a little thumbs up button underneath it. And if you press thumbs up, that'll help move the question to the top of the pile to let us know that it's a priority question. Also, this panel is being recorded, and so if you have to duck out in the middle of it, or if you know others who weren't able to take part, we'll be able to make the recording available. So before I hand it over to Erica, I just again want to thank the Chicago Lawyers Committee on Civil Rights and Quarles and Brady, and to simply say that Arts Alliance Illinois, that we're here to support your advocacy work when it comes to the arts and arts education. We are at the Alliance a statewide nonprofit 501c3 organization ourselves, and we have a large statewide network where we champion the interests of artists and arts education organizations and performing arts organizations, the entire creative sector. So we here at the Alliance are looking forward to this too, as a reminder of what can and can't be done. And I think you'll find out that probably we're able to do more than perhaps some of you might think in the nonprofit sector. So I'm going to hand it over to you, Erica, to introduce the panel and to take it from here. Thanks again.
Great, thank you, Jonathan. We are happy to be co-sponsoring this seminar with Arts Alliance Illinois. My name is Erica Spangler-Raz. My pronouns are she, her, hers, and I am Senior Counsel and Director of Pro Bono Works with Chicago Lawyers Committee for Civil Rights. And if you haven't heard about our organization before, since 1969, we provide legal representation through partnerships with the pro bono, with the private bar, and we collaborate with community-based organizations to advance racial equity and economic opportunity for all. So I encourage any of you who are interested in learning more about our organization to visit our website. We do provide pro bono representation for nonprofits, 501c3 and some 501c4 organizations that are mission aligned with ours. And the best way to get started to learn more about how we can help you is to go to our website. There's a little button that says Our Work. If you go down to Legal Help for Nonprofits and Small Businesses, you can go there. If you scroll down there, there's additional publications and resources for nonprofits doing this work. And we say transactional work is not litigation. We use all the legal tools in our toolbox, whether that's community education like this workshop, but also impact litigation when necessary, policy advocacy, and transactional, meaning not litigation, to help our community partners so they can build the capacity and provide pro bono legal assistance for them. So if you're inquiring about pro bono legal assistance, feel free to click that button that says inquiry form at the bottom. With that, I'd love to introduce our presenters today. Nora Jones is partner and co-chair of the tax exempt organizations practice at Quarles and Brady. So go ahead and put your questions in the Q&A box, and then I'm going to turn it over to Nora. So right now I am going to stop sharing.
I think you've
Great.
already stopped sharing, Erica.
Oh, I did. Okay. Good.
Hi, everybody. Thank
ahead.
you, Erica, and thanks to the Arts Alliance as well for hosting us. As Erica said, my name is Nora Jones, and I am the co-chair of the tax-exempt organizations practice at Quarles and Brady. We are a team of about 8 now, and we focus our time full-time representing, as the name indicates, tax-exempt organizations, primarily 501c3 organizations. And so these issues that we're going to be talking about today are really, they're near and dear to our practice, but more important than that, they are near and dear to our hearts because we believe very strongly that, that when possible, 501c3 organizations should be involved in advocacy. You just want to be sure that when you do it, you are doing it in the right way and in a way that best protects the 501c3 status and mission of your organization. I know that we're running a little bit behind schedule, so I want to point out a couple things up front. The first is at the very last page of the slides, and we're comfortable, of course, with these being circulated and shared afterwards. There's a slide with some additional resources, and the one that is the best in our view, you may already know of it, is called Boulder Advocacy. They have a tremendous resource library of free, easy to understand, very accessible one-pagers and tools for that cover these rules: political campaign activity and lobbying activity. So I highly recommend those. And if we don't cover something that is kind of a burning issue in your mind, check them out as well, because they very well may have that information. So let's get started. I'm going to share my screen and get this presentation started. I am going to move relatively quickly through some of these slides so that we can get to some of the more meatier kind of contemporary issues of the day. My colleague Martin Childs, if you have not met him yet, he's part of our tax-exempt organizations team. He really was critical in putting this material together. Unfortunately, he's having some technical difficulties, so you will just be hearing from me today. I apologize in advance for that. What we're going to talk about today are really 3 things, but we're going to focus mostly on the first 2. We're going to start with an overview of the very strict absolute prohibition against political campaign activity. We then are going to spend some time talking about lobbying, and in particular, lobbying that 501c3 public charities are authorized to do. And then we'll spend a much smaller amount of time, if time permits, talking about the private foundation rules, because what you'll see up front when we get into lobbying is that the Internal Revenue Code appears to give a blanket permission for all 501c3s to engage in lobbying, but then the private foundation rules take that away, that option away for private foundations. Bit of a refresher, and this comes directly from the code. If you are a 501c3 organization, you have to make sure that you are complying with the code language that says that a 501c3 organization may not participate in or intervene in any political campaign on behalf of or in opposition to any candidate for public, and that, pardon me, that's a typo, for public office. The political campaign activity is focused squarely on elections and on candidates for public elections. It is focused squarely on prohibiting 501c3 organizations from advocating for or against a candidate for public office. This does not have anything to do with lobbying or issue advocacy. We'll talk about those separately. This is very, very clearly focused narrowly on elections and campaigns for public office. There is no de minimis exception here. So the code does not provide the Internal Revenue Service or the courts with any kind of forgiveness opportunity for footfalls. This is a strict prohibition, and even a mild or insignificant violation can result in the loss of your organization's 501c3 status. This really is kind of the third rail of being a 501c3. whenever you start to do any kind of programming or communication that in any way touches on an election or a candidate, your radar should be up, it should be firing strongly, and you should be proceeding with caution. So, who is a candidate for public office? That's one of the important threshold questions here. And really, it's a very broad definition. It is any individual who holds herself out as a candidate for public office, anyone who is proposed by others as a candidate for public office, and it doesn't matter what level of government we're talking about. If that position is elected by the public, that person is a candidate for public office. One of the kind of more contemporary examples of this, as you may remember, all the way back in a different world in 2016, I think Hillary Clinton was probably running for president for about 9 months before she actually declared her candidacy. Our position, as was the position of most other practitioners in this area, is even though she had not specifically held herself out or announced formally her candidacy, she absolutely positively was a candidate for president. And so any support of her or any interactions with her, any opposition to her, could potentially run afoul of the political campaign activity. So bear in mind that a candidate for public office, again, in this context, is any person who may be a candidate for any kind of elected office, regardless of the level of government, local, county, state, national. It's a very broad definition. What the IRS does here is they employ a facts and circumstances analysis to determine whether or not the organization has conducted impermissible campaign activities. There are very, very few, almost no bright line rules here. Context is important. If the underlying intent, even if it is not stated, of your organization's letter to the editor, piece on local radio, white paper that's being circulated, if the underlying intent of that communication is to influence a public election, that is political campaign activity, and you want to stay away from that. So, recognizing that this entire field of political campaign and election-related work is fraught with risk and is very challenging, are there things that 501c3 organizations can do that have some kind of connection to elections? And the answer there is yes. However, you want to put an asterisk next to that yes, and make sure that when you say and think yes, you're also then thinking the following words: proceed with caution. The types of things that 501c3 organizations sometimes will do in connection with a campaign, but do so in a way that does not violate the 501c3 rules, are the following. They may publish voter guides. They may circulate candidate questionnaires. They may sponsor and participate in candidate debates. They may participate in get out the vote drives and voter registration types of activities. Let's talk a little bit about what each of those are. The first is candidate questionnaires. So the idea here is you may be let's say you may be an organization that focuses on issues related to homelessness in the Chicago area, and there is an aldermanic election and there are multiple candidates running for election in a ward. You may, as part of your educational mission, wish to prepare and develop a questionnaire that you would then share with the public, highlighting the various views of the various candidates for office. Again, you need to proceed very carefully in drafting that questionnaire and circulating it. The questionnaire needs to be sent to all candidates for that spot. The questions may not indicate any kind of bias or preference as to what the answer should be. The questions should permit for more than yes, no answers. You should not ask for pledges of support or fidelity to your position as an organization. The questions should represent a very, very wide variety of issues. So not just, even though you may be an organization focused on homelessness, your questionnaire should not focus just on homelessness issues. It should pull in questions and issues from a wide variety of sources. For that reason, it's very often that organizations will partner with other organizations that have different missions so that it's easy to have kind of a broad range of topics covered in a questionnaire. And then finally, you do not want to compare the candidate's position to your organization's position. Again, the idea here with the candidate questionnaire concept is you really want to try to fit this into the public education part of 501c3 and as far away as possible from indicating that one candidate might be better than the other or one candidate is really undesirable on your issues. Once you get into that kind of comparison and preferential treatment, you are in the political campaign activity world, and you're at significant risk for violating your 501c3 status. Same thing, oh, let me back up. With candidate, sorry, I'm having trouble here with the materials. Similar to candidate questionnaires is the concept of a voter guide. And the rules here are very, very similar as they are for candidate questionnaires. Voter guides need to cover a wide range of topics. You need to publish all of the candidates' responses without editing them. You have to make the guides widely available. You can't direct them just to kind of a preferred or focused group. You need to be very sure that, again, in the presentation of their responses and their answers, you are not indicating that one candidate is better or worse than the other, or that certain candidates adhere to your values as an organization while others do not. And ways that the IRS has seen that happen are as truly obvious as listing the candidates, listing the questions, having yes or no answers. And if a candidate gives an answer that does not mesh with your organization's values and mission, putting like a big red X, kind of like a skull and crossbones next to them. And when candidates answer yes, putting a big green check mark or a smiley face. You want to, that seems very obvious, but it happens more often than you may expect. You want your materials to be as, to borrow a tagline, as fair and balanced, as neutral as possible, and really as kind of unsexy as possible, just very straight, broad range of information, no editorializing, no preferential views given. Candidate forums and debates. This is another activity that organizations, 501c3 organizations, are able to engage in without violating the political campaign restriction. However, again, you have to proceed carefully. Good general rules are that all candidates have to be invited. Now, there are, there's some, I think, rules of reason to be applied, especially early in certain primary seasons when there's 50 candidates running for a position. You have to be careful, but there may be some opportunities to kind of draw a line as to the number that need to be invited. The candidate forum or debate has to be publicized widely. You need a neutral moderator, not somebody who is so identified with a particular view or political party or candidate that even just their participation indicates some political campaign views. Same thing that we've talked about before, no comparing views to those of the organization. You have to be sure that the candidates who are participating are given equal opportunity in terms of timing, publicity, location. If rather than doing, a forum or a debate where everybody is on the stage at the same time, you're kind of doing a series of debates, you can't invite one candidate to participate at your well-attended annual lunch, and then the other one you invite to a breakfast at 6:30 in the morning, knowing nobody will come there. Everything has to be equal. Everything has to be fair. Everything has to be as non-preferential as possible. And similarly, the questions that are asked cannot just be focused on your particular mission and issue. It needs to represent a broad range of issues. Again, this is why you'll often see when 501c3 organizations get involved in candidate forums and debates, they often will do so in collaboration with other organizations so that it's easier to tick off some of these boxes. The last two options that 501c3s often engage in are get out the vote drives and voter registration drives. No surprise here. These have to be conducted in a truly impartial manner. You cannot focus your efforts registering and getting to the polls those individuals who are more likely to vote for one candidate over another. You cannot pay people to vote. You cannot give people prizes for registering to vote if you are not also giving, those kind of like the tchotchkes to anybody that stops by your table. You cannot focus just on districts or wards where there are contested elections with candidates who may or may not, who you either would support as an organization or would not. There is some ability to make an exception there if your focus is on getting out the vote and registering voters who historically have a historical record of not registering and not voting. You can have a particular focus on getting out the vote in underrepresented communities that don't have a strong track record of voting. So that's voter registration and voter get out the vote drives. Again, I want to make sure, I see that there's some questions, and so I do have some examples that I'll stop here, but let me just take a look at these questions really quickly so that we can try and cover some of these. I'll say up front, I'm almost certainly not going to be able to get into the weeds on very specific examples, but we'll do what I can here. So I see a question about young program participants engaging in campaign activities. Can you publicly support them and their work or opinions, or does that count? That almost certainly is going to count as the organization supporting a candidate. If you have a program that encourages just general political participation in a political process by young people, and those young people are able to participate, kind of on with any party and in any manner, you could theoretically be publicly supportive of their general work participating in the political process. But if the work that you are amplifying and showing is work that is clearly supportive of one candidate or clearly in opposition to another candidate, I would be extremely cautious and extremely reticent to be comfortable with that, because that is going to look like you are using the organization to support the work and the views of one candidate over the other. Let's see, a question about making public statements.
Nora?
Oh, yes.
Nora, so here's a question that came up, and I made the mistake of misinterpreting what the acronym was for. So would an LSC, meaning local school council, would an LSC representative be considered a candidate for public office? They're elected by the public, but they're limited to a specific school. And so would that be prohibited activity?
I have not looked at that specific issue before, but my initial reaction is yes, it sounds like they are a candidate for public office, and the 501c3 organization should not be supporting or opposing particular candidates for that spot.
Great, thank you. I think I agree with that. If it's easier for you, Nora, I can just run through these questions in the Q&A, or do you want, okay. So we have a question from Pat that says, how do you critique or take public positions against an incumbent who is both in office now and seeking office now? So example is, how is criticism of the current presidential administration not a problem as the president is also currently a candidate?
Yeah, that's a great question. And unfortunately, there is not a great answer for that. It is really hard and kind of fraught with risk. The organizations that are able to do that, or that have gotten comfortable with it, typically will have a long track record of very regular kind of public statements, not about a candidate or perhaps not about the particular president, but about policies. And they do so in kind of a regular routine manner, so that you have a track record indicating that your communications and your activities are not tied to an election, but instead are just part of your regular process and procedure of evaluating policies and governmental actions and expressing a view on those. But it is, it's a very tricky and unclear area. Are you gonna, okay.
Do you want to go through the rest of the political campaign activity examples?
Yeah,
there's other questions that are in the chat, but
why don't we do that? So, okay.
Do you want to focus on that, and I can try to see if we could do that? Yeah.
Perfect. Okay, so a couple activity or examples that came up as we were preparing for today. One of the questions was, let's say that you are a 501c3 art gallery, and or an art organization, and you work with a lot of artists, and obviously artists have views and have strong views. Can you, as a 501c3 organization, can you amplify, circulate, share, highlight political art prepared by your members or the artists that you work with? Very, very lawyerly answer here. It really depends. If you have a kind of developed procedure or exhibition or focus that looks at, how art has reflected political concepts and political ideas over time or historically, and you're looking at, art reflecting a view from a variety of different perspectives and political viewpoints and party loyalty and affiliation, then you likely could get more comfortable with that. If instead you are going to have an exhibition, or you're going to highlight art that is consistently, we'll just say anti-Trump or pro-Biden, you are in some pretty risky, you're on risky ground there, because it will then appear that you are using your 501c3 status only to amplify the political views in support of one candidate and opposed to the other. Whereas if you could take a more kind of academic approach to what has political art looked like in, the 21st century versus the 18th century, something like that, you would have more leeway. Also, a different topic that came up is, well, what do you do if you work for a 501c3 organization? You're clear on the political campaign prohibition, but you want to speak out individually. Are you prohibited from doing that? And the answer is no. Certainly there are lots and lots of 501c3 executive directors and staff members who are very, very involved in political campaigns and in the political process, and they do not lose their First Amendment rights just because they work for a 501c3 organization. But what they need to do is they need to be clear that when they are sending a letter to the editor, signing on to a public statement, speaking at a campaign event, that they make clear that they are there in their personal individual capacity and not representing the organization that they work for. It can initially feel kind of like an awkward, clunky bunch of words to be saying, but you want to train yourselves and your staff to get used to that and to actually say it, to say out loud, to put on the paper that you are speaking in your individual capacity and not on behalf of the organization. And then the final example that came up in advance of today's program is, well, what about hosting a town hall discussing the issues facing the community? I think town halls are great, and I think that there is very, very little risk in just having a town hall to discuss issues facing the community, surface issues, let the public share ideas and share views. What you need to do as the 501c3 host is keep it to a surfacing of issues and a surfacing of kind of general concepts of solutions, but stop it before it gets into discussions and a focus on, so we need to organize and we need to make sure that, Trump is not reelected. You cannot let it veer into the political campaign world. And when it starts to kind of feel like it's getting that way, you need a strong moderator that can step in and say, just a reminder, we're a 501c3 organization. We are prohibited from getting involved in election-related matters. We can't discuss those here. Those should be focused on at a different event, but not here. Again, not easy and always comfortable to do, but important for you to do it and important for you to have the record that you did it, because those types of records can be very helpful in the event you are faced with an IRS audit. Now, I think in the interest of time, why don't we switch to lobbying, because there's a really key and critical point that that's contemporary that I want to be sure we focus on and just get across. So what we just covered was the political campaign prohibition that focuses on candidates for public office. Lobbying is another type of advocacy, but what lobbying focuses on is legislation. You need legislation to be in the lobbying world. Again, here we start with what the code says the rule is. And what the rule is for 501c3 organizations is that no substantial part of a 501c3 organization's activities may consist of the carrying on of propaganda or other attempts to influence lobbying. As I mentioned up front, and as we probably won't have time to get to, but you'll see later in the slides, private foundations lose this ability. So really what we're talking about here is 501c3 organizations that are public charities. And their rule is that no substantial part of their overall activity can consist of lobbying. What that tells us is two important things. The first is lobbying for public charities is not prohibited. The code specifically recognizes and gives permission for 501c3 public charities to engage in some lobbying. And the second important thing that it tells us again is that what this is focused on is legislation, legislative lobbying, and not broader issue advocacy. The questions then that come up is, well, what is lobbying exactly, and what is substantial? And the answer there depends on which of two tests applies to your 501c3 public charity. The default test is what we call the no substantial part test. The alternate test is a test that's called the 501h expenditure test. To be subject to the 501h test, you have to actually file an election with the IRS. It's one page, it's very easy, but you don't get the 501h test unless you have filed that election with the IRS. For lots of organizations that engage in lobbying, the 501h test typically is preferable for the reasons that are listed here. If you don't make the election, then you are living in and have to operate under the no substantial part test. Truly, we don't know what this test means. And that's not a failure of quarrels. This is true for everybody that practices in this area. There is very, very little guidance under the no substantial part test. We don't know exactly what lobbying means under this test. We know that it means attempting to influence legislation. However, things are very, very murky and unclear after that. There is no bright line threshold for what substantial is. So what the IRS might feel is substantial for one organization is not necessarily what they're going to think is substantial for the other organization. It is very, very much a facts and circumstances based analysis. One of the things that we do know is that they pull in this test, they don't look just at how much time or money you have spent on an activity. They also look at how much the value of volunteer time that you have mobilized. So as an example, if you are under the no substantial part test and you organize a lobby day down in Springfield and you pack the buses with a bunch of parents who are going to go down and speak to the state legislature about education-related issues that need to be resolved in the budget, you are going to have to value all of that volunteer time and count that as lobbying that you have done under the no substantial part test. So for this reason, the no substantial part test, particularly if lobbying is something that you are going to be involved in on a somewhat regular basis, this can be a very difficult test to live in. Luckily, test number 2, the 501H expenditure test, is very accessible. You can elect to get into this test really at any time during a fiscal year, and it remains in effect until you take steps to pull it back. The benefits of the 501H test are that it gives you more specific definitions and it gives you objective limits as to what counts and what does not count. Under this test, again, lobbying is any attempt to influence legislation. You need legislation. So legislation is an action that is adopted or rejected by a legislative body. So we're talking about Congress, the state legislatures, city council, the county board. You need a governing body made up of legislatures. It does not include administrative or regulatory action, and it typically does not include executive action. Legislation includes bills that are currently making their way through the legislative process. It also includes legislation that is being developed and actually written. Another benefit of the 501H test, in addition to having some more specific definitions, is that it is an expenditure test. It does not look at facts and circumstances. It looks at dollars. So it looks at how much money have you spent on a legislative activity? How much staff time, including the allocable portion of overhead and benefits and the like? It looks at dollars, and it gives you a runway to say, well, here's how much we can spend. It gives you a limit on lobbying expenditures that is based on your overall program budget. And again, I don't want to spend too much time getting into the weeds here. Boulder Advocacy in particular has some great kind of explanations of how you calculate this, but you can see here, exempt purposes expenditures essentially means your budget, your overall budget. And depending on the size of your budget, you can easily calculate how much are you allowed to spend on lobbying during the year. The good news here is that if you blow it, if you go over your lobbying limit for a year, you don't lose your 501c3 status. You have a penalty tax. You don't lose your 501c3 status unless you blow the limits for a 4-year period. So it gives you an awful lot of grace and an awful lot of runway. Quite frankly, if you keep blowing it for 4 years in a row, I find it kind of hard to criticize the IRS for yanking your 501c3 status, because this really is a very generous test with a lot of opportunity to kind of course correct and get things right. I would just advise you to take a look particularly at Boulder Advocacy for more information on how you calculate this number, but it's pretty straightforward and fairly clear. Again, what counts as lobbying is the total amount that you spend on a legislative or lobbying action. It can include grants that you spend for lobbying. It includes, obviously the time that the dollars that you spend when you hire a lobbyist. If you have your own staff engaged in lobbying activities, it includes their compensation plus, the overhead and the like. But the nice thing again here is that the 501H test gives you a clear way to measure and a clear way to calculate so that you will know how much is okay, and you'll be able to track that throughout the year. Under the 501H test, there are two types of lobbying. There's direct lobbying, which essentially means working or communicating directly with the legislatures and the people in their office about specific legislation. And the second is grassroots lobbying, which means interacting with the public and encouraging the public to contact their legislators and express a view, vote yes or no on this bill. One thing that I really want to be sure that we cover today, just given where we are on the calendar and where we are in Illinois, is the fair tax amendment. And I know that this comes up later in the slides, but I'm going to stop here and emphasize this. Under the 501c3 rules, the fair tax amendment is legislation. And it is now at the kind of point in its journey where, because it is going to the public, and the public now is acting kind of as the final legislative body on this, on the ballot measure to decide whether or not it passes, the public now is considered the legislative body. And so efforts to encourage the public to vote yes, or I suppose vote no, on the fair tax amendment, that is lobbying under the 501c3 rules. And if your organization is doing that, if your organization is engaged in efforts to get the public to support or oppose the fair tax amendment, that is lobbying activity. If you have made the 501H election, it is direct lobbying activity, and it needs to be reported as such on your Form 990 on the Schedule A. You want to know now that that's what you are doing so that you can be sure that you have the right tracking methods in place, you have the right procedures and protocols in place, you've had the right people in your organization take a look at your efforts to make sure that, if you are in the 501H test, you're tracking them correctly and you can report them appropriately. If you're in the no substantial part test, you want to be sure that you're comfortable that the amount of time you're spending on this isn't too much, even though we don't exactly know what too much means. And if you have some concerns, consider perhaps making the 501H election. But the main kind of takeaway here is that the fair tax amendment is legislation, and encouraging the public to vote a particular way on the fair tax amendment in November is lobbying under 501c3 rules and has to be reported as such by the organization. One side note is that you may be familiar with this already, but there is, of course, a whole host of other registration and reporting rules that apply under Illinois law to lobbyists and lobbying activity, that those are separate and apart from the 501c3 rules, but you want to bear in mind that those do exist. So particularly if you are frequently interacting with legislators and your people in Springfield or people on the city council, we'll talk about the city council in a second. If you're interacting with people down in Springfield, you very well may have Illinois registration and reporting obligations for lobbying that are similar to but different from these 501c3 rules. Same thing now in the city of Chicago. There is a very painful move to expand the lobbyist definition and reporting and registration requirements for interactions with the City of Chicago and City Council on local issues. These are, again, separate and apart from the 501c3 rules that we are covering here today. They've been kind of put off and extended multiple times, mostly due to the pandemic. And as of right now, I think we're all expecting that they will become effective in January, or some version of them. But that's something else to just keep on your radar, that the city now has its own set of rules that, again, somewhat similar to these, but different enough that they warrant their own review. Okay, and in the couple minutes that we've got left, I want to skip ahead and talk about what can public charities do. Remember that what we're talking about here is legislation, lobbying for legislation. So advocacy that does not involve legislation is fine. It is not covered by these rules to begin with. There are 4 specific exceptions, or 4 specific concepts that the Treasury regulations specifically say these are not lobbying. And most organizations that we work with are able to make very good use of these specific exceptions. The first is that non-partisan analysis, study, or research that is made available to the public is not lobbying, specifically not lobbying under the code. The second exception is for examinations and discussions of broad social, economic, and similar problems. That is not lobbying under the code. Technical advice is not lobbying under the code, but put an asterisk there. This is very, very limited and almost never works in real life. And self-defense communications, another asterisk there, very, very narrow, rarely works in the real world. Let's talk a minute about nonpartisan analysis. To qualify under this exception, this is kind of your classic white paper exception. It has to be an independent and objective exposition on the subject matter. It needs to be full and fair. It has to show all different viewpoints in a fair and balanced way. It can advocate for a particular position so long as there is enough information and fair and balanced views in the rest of the document that a reader could come to a different independent communication. It even can refer to and reflect a view on specific legislation. It has to be made publicly available to the general public. You can't just focus the readership on a particular group. It really has to be made widely available. But this nonpartisan analysis, study, or research exception is the one that organizations, I would say, make the most use of, and it's kind of your classic white paper with a good, fair, and balanced analysis in it. Examinations of broad social, economic, similar problems. Again, this is pretty similar to the white paper concept. It looks at, what are the causes, for example, of poverty, and what types of things could be done to improve the resources for those in poverty. It cannot focus on specific legislation at all. Technical assistance or advice. So this exception works only if your organization has received a written request from a governmental body or a committee. It does not work if you get a request from one legislator or from one city council person. It has to be in writing in the name of a government body, in the name of the ethics committee, in the name of city council. And your response has to be made available to that entire committee as well. So what happens here in real life, what we experience is that often an organization might get a call from one person sitting on a committee saying, hey, what do you think about this bill that we're going to be looking at? You will not qualify for the technical assistance exception to lobbying if that's your fact pattern. You need the request to come in writing from the body itself. If you get that, you can then respond in writing to that same body, and you can express your view on the legislation that was sought. And then the final exception is for self-defense communications. This covers appearances before a legislative body talking about a potential legislative decision that might affect the existence of the organization, its powers and duties, its tax exempt status, or the deductibility of contributions to it. Unfortunately, in practice, this exception is extraordinarily narrow. And the IRS has specifically said that this does not cover organizations going to Congress or going to a state legislature and arguing for better funding in the budget. It seems like that should count under the first bullet point, the existence of the organization, especially if you can, very accurately say, without better funding, our organization is going to close up shop and will no longer exist. The IRS has said, no, that does not count. And we are talking about things like changing the language of 501c3, changing the language or the concept of unrelated business income. That is what counts under this exception. So again, it's so narrow that it almost never really works in practice. I know that we are at time. I'm going to skip the private foundation concept, but just remember there that the main takeaway is that 501c3s that also are private foundations, they lose the ability to participate in lobbying at all. So the only way that a 501c3 organization can lobby to begin with is if it is a public charity. Erica, I think I'll stop it there and see if we can maybe cover a question or two in the time we've got.
Yes, thank you so much. And I think it's really great that you actually pointed out kind of the issues that some of the private foundations face on their end to be able to give grants to public charities. So we have two questions I think that would be really good if you could kind of discuss a little bit more. One is from an organization that serves people with disabilities, and they want to give out information and statements directly from the candidates on their positions related to serving people with disabilities. One of the candidates has not responded. Can they put out something that says no statement for that particular candidate? They've sent it to all the candidates.
Well, that's a tough one. I think that it will depend in part how many candidates there are. So if let's say there are 5 different candidates and you have responses from 4 and not from 1, I would be more comfortable with this approach in terms of publishing the statements and including a no statement given for the 1, because that to me doesn't seem as it doesn't seem to cast as negative a view on the non-responsive candidate. If there's only 2 candidates and only 1 has responded, I would strongly reconsider setting up the website or publishing that information to begin with, particularly given the fact that, if you're a disability community and these are statements about their, commitment or positions on the disability community, and you publish one person's statements and a no statement for the other, it will look like you are more supportive of, or that the one who did respond is a more preferred candidate. There's actually, and again, on the Boulder Advocacy webpage, there's some interesting guidance and some interesting considerations for organizations, more in like the candidate forum or candidate debate context, where, well, what do you do if there's only 2 candidates and 1 won't participate? Can you still have the event? And really the answer there is probably no, because if you're moving forward highlighting only 1 candidate, it's incredibly hard to make that look like anything other than supporting that 1 candidate. And I think that those principles would likely carry over to the publishing of statements as well.
Thank you. So the next question is for a nonprofit that is a chorus organization, and they were invited to sing for a particular political party. And so they didn't think they would be able to do that, even if it was because they were invited to sing at that event. So is that something that they would be able to do? They were unable to do it before because they didn't think it was okay.
Yeah, I mean, I think you probably could do it if you went the extra step of sending a note to the Champaign County Republicans and saying, hey, we're singing at a campaign event, we were available to sing at yours. What you want to do is establish a record that you are available to do this for both sides. So I guess that's what I would say as a lawyer who was advocating for you, if you were definitely doing this. But I think that your instincts were right on, and it feels so murky that I would probably avoid it as well, and just let individuals know that if they wanted to do it, they'd have to do it without using our organization's name or resources.
Yeah. Thank you for that. And then we have one more. Is it possible, I'm just going to read this as it's written. Is it possible for organizations to publicly support Black Lives Matter and share legislation in support of, i.e. sharing budget proposals, police brutality legislation, no cops in schools, etc.?
Yeah, so I'll take the first part.
I'm assuming this is going to be a 501c3.
Right.
Yeah.
I mean, yes, absolutely. 100% it is possible for 501c3 organizations to support Black Lives Matter and to make clear, strong, powerful statements in support of Black Lives Matter. Yes, to that part, kind of unequivocally. The second part about sharing legislation in support of it is definitely, the answer there is it depends. Are you sharing kind of the broad range of potential legislative approaches without commentary? Are you sharing like a white paper that is analyzing a number of different potential approaches to supporting Black Lives Matter through legislation? Or are you sharing specific legislation and saying, this is what we need, support this? So the devil will be in the details in terms of what exactly you mean by sharing legislation, to whom are you sharing it, and specifically what is it that is being said. But keep in mind that if you are a 501c3 public charity, even if that sharing of legislation is in fact lobbying, you still can do it as long as you're doing it under the limits or within the limits that apply to you. So just because it might be considered lobbying, so long as you are a 501c3 public charity, the analysis shouldn't end there. Then you just think about, okay, well, it's lobbying. Do we have the resources and the ability to appropriately track and report this and go on from there? The same would not be true if the question was, can we support Black Lives Matter by highlighting, candidates who have strong Black Lives Matter track records? There, the answer is a very clear no. But in the world of sharing and sharing information about legislation, I think it's a probable.
Thank you for that. I'm going to squeeze in one more because this has come up twice. And this really has to go with the enforcement issue for the IRS. There were some comments that churches are getting away with, telling their congregation to vote for or against a particular candidate. And so the Johnson Amendment has not been repealed, even though there have been efforts, which is that particular law. And so the question is coming up, does the IRS really have the resources to watch all of this? And what is the repercussions? Like what happens if you do something that you weren't supposed to do, particularly in the area of prohibited activity?
Yeah, so I mean, very good and practical question. I mean, no, they do not have the resources to watch all of this. But yes, they do actually come after 501c3 organizations. Not all of them, almost never churches. And it sounds like you correctly pointed out that churches are perennial violators of these rules. I will kind of editorialize for a moment and say that in this area in particular, I think churches just, as a general rule, don't feel that these rules apply to them, and they are going to do what they are going to do. And I think that the reality is that for churches, the IRS is very hesitant to get into First Amendment battles with them, given the very low resources that the IRS has. That said, the IRS does every year, for sure, come after 501c3 organizations particularly for political campaign intervention. They usually publish reports on a regular basis indicating what their audit activity is in this area. And it's pretty low. I mean, it's definitely low. I can't, I wouldn't pretend otherwise. But, that's kind of, that's not great consolation if it happens to you and to your organization. At a minimum, I think best case scenario is you have a record that you can show if something bad happened. You can have a record that shows, oh my gosh, but look, it was totally against our policies. This was just a complete mistake. We had, we look at these actions we took as soon as we knew that it happened. We took the web page down, we sent a note, we put a notice up, like we did all this stuff to try to correct it. In that kind of situation, it's possible they maybe let you go with just a slap on the wrist and some additional reporting obligations. It's more likely that at a minimum, they're going to give you a tax. But in the meantime, you are going to be operating under this fear that you could literally lose your 501c3 status completely. And that is not out of the question, and it's not unheard of. So, I think for us, our position in working with organizations and advising them is, I think get comfortable being as aggressive as anybody would be out there, but given the severity of the risks with the political campaign world, it's not a good place to test the limits, because even though we know that audit activity is low and the IRS is really strapped, if it happens, it can be fatal for the organization, just absolutely fatal.
Great. So thank you so much, Nora. It is always a pleasure to work with you on these presentations, and we've done several of them over the years. So we're really grateful for your sharing your expertise and your time with our audience. So I am really grateful. We've answered so many of the questions through the chat and through the examples. So thank you for all of your questions. I'm going to turn it over to Jonathan to close us out.
Yeah, I just want to add our thanks to Nora and to Quarles and Brady. It was very helpful, and we appreciate you sharing your expertise. And also, it was an honor for us at the Alliance to partner with the Chicago Lawyers Committee. So Erica, our thanks to you. Just to give you a heads up, there'll be a survey link that you can give feedback in your browser when you get out of this. So please give us your feedback on what you think about this webinar. And so go out and be engaged civically, but remembering the rules and requirements. We hope this was helpful in that. And I hope that you have a good day and a good week. Thanks.